Everybody. Oh, recording in progress. Okay, I've got to click got it here, which I'm sure the rest of you will do. Okay, I'm going to keep this fairly brief. It's not going to be a heavy corporate or company law lecture. And I think it's important that we stay practical about this. We deal with a lot of small businesses here. And the main focus of every business owner is to be driving the business on and hopefully making some money. And usually when you have to start looking at company law issues, employment law issues, it could be indicative of very good management and getting things done in advance. But in my experience, it's usually indicative of some problem has arisen and you need a bit of help to sort it out. And in that regard, the one thing I would say is go for the help probably before you think you need it. Frequently dealing with companies, things are left too late, and then there are bigger problems than there need be. So I'd really counsel taking advice early, and often that advice can stay quiet behind the scenes. There's no need for a solicitor to put his or her head up and be formally representing the company. Often you can get counsel behind the scenes and then go on and get things done yourself. Okay, first of all, the Companies Act. Now, here we are in 2021, but the Companies Act is still giving rise to debate, and it's been implemented, even though it's called the 2014 Companies Act, it's with us since 2015. And it really just designated different forms of companies, such as the one you're most familiar with, the LTD Limited. Sorry, I should have mentioned the three things I'm going to discuss: the Companies Act, the Corporate Enforcement Authority, and then the Small Company Administrative Rescue Process. But just going back to the Companies Act 2014, as you can see there, it introduced the Ordinary Private Company Limited by Shares, LTD, designated activity companies. You'll be familiar with things like Ulster Bank, DAC, things like that. There are other companies as well, which we'll come to in a minute. But some of the benefits were that only one director was required, previously at least two. And you'll all be aware of what we might call family companies, where often the spouse was no more than a token director and wasn't really involved at all. And in that context, it would seem rather unfair to have a spouse who has nothing whatsoever to do with the business or the company being on the line as a director with director's responsibilities. So I think that was a sensible amendment. The DAC company are designated activity companies, which, as I mentioned, some of the financial institutions, they'd be designated activity companies. Unlimited companies, one of the requirements of being a limited company is that you publish your accounts, and there's disclosure on what your accounts are. If you don't want to publish accounts, you can decide to form an unlimited company, but there are consequences, obviously, given away by the name unlimited, because whereas with your limited company, the whole purpose of setting up a limited company is that your liability is limited. The business itself has assets and has debts, but your house is not on the line, unless, of course, you sign up a personal guarantee, which is another day's work. But if you want to be a little bit secretive and have an unlimited company, you can do it, but you take the consequences and your liability is unlimited. So if things go wrong, all your personal assets would also be on the line. The CLG, the guarantee company, would be used mostly for charities and sports clubs. A lot of you will be familiar with a very well-known one here locally would be County Wexford Community Workshop and Enniscorthy. That would be a CLG. And don't forget that while we're talking about companies governed by the 2014 Companies Act, many businesses are run as sole traders, where one person is involved, or where you'd have more than one involved, but not a limited company. It's a partnership. In a partnership, there's often a bit of confusion. Is the partnership a separate legal entity from the two people who are running it? And the answer is no. A partnership is a partnership, but the two individuals, if it's just two in a partnership, are both fully and personally responsible for their own taxes. and for the liabilities of the partnership. It is not, a partnership is not a limited company. Now, there is a new animal which concerns people in the legal business like myself, where you can form a limited liability partnership. So a partnership can have limited liability, but your usual high street partnership of a couple of people running a business that is not incorporated as a company is not a limited entity. And you need to be careful about that. There are certain other changes which are not that commonly used, but to do with capital reductions, solvent winding ups and things like that. If you decide to finish with a company, you have seen situations where the promoters in the company, rather than selling the business, just decided to dissolve it, and one would take certain assets and the other would take certain assets. Now, you can do things like that if there are no debts owed and provided you're not pulling the wool over creditors' eyes, but that's a rare enough occurrence. Now, I'm just moving quickly to the Corporate Enforcement Authority. You're all familiar with the ODCE, the Office of the Director of Corporate Enforcement, which is under the Department of Enterprise and Trade up to now. And that was quite high profile when we had the various banking collapses and scandals and allegations of fraud and misleading and all that. And you'll be aware of some very high profile criminal trials, some of which were successful and some weren't. You'll also be aware that there was some criticism of the ODCE in that regard. But in fairness to the people involved, I think they had very limited experience, and it's hindsight is a wonderful thing, of course, but peculiar to consider that people with very little experience of criminal law were the people chosen to prosecute possibly one of the most high-profile criminal cases in the country. The whole idea of the new agency is that it would be a separate statutory agency, the Corporate Enforcement Authority. Some people have described it as the FBI for private companies or for companies. And you can see that they're beefing up already with added Gardaí, particularly, who would be investigators of various types of crime, including corporate crime. And a lot of extra Gardaí will be allocated to this office when it comes into being. And it's expected to come into being formally towards the end of this year or by spring of next year at the latest. No guarantee on that, obviously, but that, I understand, is the plan. Does your regular director of a company here in the Southeast have to worry about the Corporate Enforcement Authority? I would say only if you're up to something a bit hooky or a bit crooked. And one of the fundamentals, I was asked to give a talk to directors of companies some time ago, and really there's a very fundamental word that we're all familiar with, and it's called honesty or transparency. If we're running a business, we all have access to, or usually we have access to, an accountant. And I think it is very important that you keep very close to your accountant, not just at the end of the year to get the figures right, but I think on an ongoing basis, it's very important to have open conversations with your own accountant, and indeed sometimes perhaps to take advice from a separate accountant if there's something you wish to discuss in advance of doing it. I think it's important on all of these things to take advice early and not to take chances. So apart from that, I don't think your ordinary business has anything to worry about from either the ODCE or the CEA if things are being done in an open and transparent manner. The downfall for many directors in small companies is that they know there's something going wrong, but they don't take any advice. It continues to go wrong, and then you're wide open to an accusation that you got credit from your creditors at a time when you knew the company was unable to pay its debts. And if that's proven, then you are personally liable for those debts. You can't hide under the protection of limited liability. I think that is the most fundamental message of this talk today, is that if things are going wrong, get advice quickly, change the picture, perhaps negotiate with your creditors to spread things a little bit. Consider for a moment putting yourself in the position of a creditor who's owed money by a business. And if the owner of that business comes to you and says, look, I'm very sorry, but we're going to have to slow down payment for the following reasons, would you, as a creditor, push the button and immediately try and liquidate that company? Will you get paid? You might get nothing. Or would you at least have a conversation and say, right, let's talk about this. You look at your own business and you say, right, we can absorb this over a period of time. Early conversations like that can be very helpful and very productive if a company finds itself in that situation. And I would always encourage early discussion on that. Now, the functions of the CEA, obviously encouraging compliance, investigating suspected offences and non-compliance, prosecution of offences, referring indictable offences to the DPP. Indictable means more serious than summary, and the exercise of certain supervisory functions with regard to liquidators and receivers. As you probably know, liquidators and receivers already have pretty severe obligations where, some people think, we get a friendly liquidator to get this thing liquidated quickly. Liquidators have very serious responsibilities to report, even at the moment, to the ODCE. They have very serious responsibilities to report any odd behaviour in a company to the ODCE, and they themselves are liable to prosecution if they don't. So in my experience, you will not find a liquidator who's going to allow directors to hide behind wrongdoing in the lead up to a liquidation. Now, the current ODCE doesn't have resources to deal with complex cases. I mentioned that earlier. This is why the CEA, the Corporate Enforcement Authority, is being created. And smaller cases of corporate crime will also be dealt with, and they'll detect and protect against cyber breaches. That in itself is a form of corporate crime where you have people trying to breach security. And the present slide goes back to what I said earlier, be fair and honest. And I think that is one of the most fundamental things in dealing with running a company. Now, to turn to the SCARP, or the Small Rescue Administrative Process. Again, I'd imagine you're all familiar at this stage with examinership, which has got a lot of exposure over the last number of years, where a company can call in an examiner and seek the protection of the court, which can be 100 days or more in certain circumstances. And provided the company could show that it could be financially viable, if a program of reorganizing creditors was introduced, then it would be allowed to continue. Now, it was an expensive exercise involving approval by the High Court, and the whole idea of SCARP is to eliminate any need to go to court. So you've got to engage. It can't be the company's own accountant, although the company's own accountant could be very good at, and should be good at, producing a simple picture of the company, its history, its employees, its assets, its debts, and all its current liabilities. In the same way that a statement of affairs might be prepared if a company was considering liquidation. So once that preliminary work is done, you then got to engage a process advisor, who's an insolvency practitioner, if you like, and that process advisor will then write to all the creditors. There'll be a meeting called of the directors, and then a resolution will be passed to engage in the SCARP process, and the statement of affairs will be sent out to all creditors. Now, if the creditors accept the proposal, then there's no court involvement at all. So it's not the company seeking to avail of SCARP that engages in a court process. It's only if a creditor objects and feels that he's not being treated fairly, then it's the creditor who pushes the button on referral to court. And the test, again, some of you might be familiar with various cases where people have availed of personal insolvency and where some creditors challenge. And you might have seen some court decisions where the court decides, no, I'm not accepting the creditor's challenge, the challenge from the bank or the building society, because judges might say it's quite clear that the building society will be better off allowing the creditor to avail of personal insolvency rather than going bankrupt. Now, in the same way, the creditor in a SCARP process won't have a legitimate objection unless the creditor can show that they'd be better off in a liquidation. And that would be rare that a creditor would be able to show that if the whole company was liquidated, and liquidation, by the way, is the end, it's the death of a company. It'd be unusual that a creditor could show that liquidation would produce a better result than a SCARP process, which would allow the company to continue by reorganizing its debts. So it must be a small or a micro company. I'm not going to go into the details of that, and I'll tell you why in a few minutes. You can take it that most what we'd call ordinary companies would fall into the small or micro company bracket. That's why this legislation is being introduced. And it must be a situation that the company is unable to pay its debts or likely to be unable to pay its debts. Now, again, go back to what I said to you earlier about directors possibly taking on personal liability instead of company liability for debts that are incurred when the company is unable to pay. And I think you'll see again why it's so important to take advice early. If you feel the company is struggling a bit, that's the time to take advice and say, we're getting into difficulty here. From that moment on, if you as a director buy goods from a creditor, the creditor can then say, hold on a second, you knew at the time you ordered those goods that you weren't able to pay, the company was in difficulty, and I'm going after you personally. So you want to avoid that. Again, it's just about admitting things early, having a quick chat with your, serious chat with your accountant and deciding what to do. To avail of SCARP, the company must not have been in liquidation or had any order made for its winding up, and must not have had an examiner, for instance, appointed in the previous 5 years. So you can't have done an examinership 3 years ago and now do the same thing again with SCARP. Now, just small company there, you can see the limits are quite high, so annual turnover under 12 million and a balance sheet total of less than 6 million. I think that would cover an awful lot of businesses that we know, and less than 50 employees. Micro company then would be less than 700,000, balance sheet total of less than 350 and less than 10 employees. So here we are. The synopsis of the steps would be to engage the process advisor, that's an insolvency practitioner, prepare the statement of affairs. Again, I mentioned that that can be done with the assistance of your own accountant. Then you get the process advisor's report. So your accountant statement goes to the chosen process advisor. And then the step 4 is you engage in the rescue process. The process advisor sends out the statement of affairs to the creditors and stakeholders with his rescue plan. And it's up to the creditors then to file a notice of objection if they want to with the process advisor and with the court. But the court will sanction the plan unless it's unfair or unfairly prejudicial to the objecting creditor. And I've mentioned that already. If the creditor could show that they'd be better off with a liquidation, which is highly unlikely, but if they can show that, then the SCARP process will not be approved. So what's the whole purpose of SCARP? Again, as I mentioned earlier, it's to allow creditors to be paid a portion of the debt or to reschedule debt. Must show that creditors are better off financially than a liquidation process, and must show that the company can be financially viable in the future. If the vote doesn't pass, then the process advisor must report the reasons why to the board of the company and set out recommendations for next steps, which could involve and probably will involve liquidation if the SCARP process is not accepted. So that's a quick synopsis. I'd like to mention that there is, it's not that short, but there's a very, very good article on SCARP published for the ACCA, the accountancy body, a technical fact sheet on the small companies administrative rescue process, which was put together by Tom Murray of Friel Stafford. I think Friel Stafford would be a very well-known insolvency practice and financial advisory practice. So Tom Murray of Friel Stafford, I don't have any connection with that firm, just to for the interest of full disclosure, but Tom has written an excellent article and quite a detailed article on the small companies rescue process, if you're interested in reading more about it. But again, I would say to you, rather than be reading an awful lot about it, if you're involved in a company, or even if you're an advisor advising a company and you get the hint that things aren't going the way they should be going, that's the time to call a meeting, set things out clearly, engage with somebody who's in the insolvency space. Don't be afraid of it. Get a bit of early advice. And if you have to avail of the process, well, it's time to get on and avail of it. But perhaps you'd get some reassurance and some, what I'd call some ordinary restructuring, which I mentioned about ringing maybe your major creditor and asking them to spread things for a while. That's a conversation that sometimes is acceptable to some people, and you don't have to involve yourself in a formal process like this. But if it's going the wrong way, early advice is the key. So that's it, ladies and gentlemen, in a nutshell. And if you have any questions, I'd be happy to try and deal with them for you.
Thanks, John. We'll open it up to the floor now for any questions.
Or if people would prefer to maybe send an email in later on with a query, I'd certainly do my best to give you a steer in the right direction. That's also available, and happy to do that for you.
Thanks, John. Just in relation, I suppose, to the SCARP, and you know, obviously we know the small and micro companies' contribution to our economy certainly can't be understated, and you know, it'll be in terms of the economic recovery, this sector will be key to recovery. But in relation to the SCARP, what's the time frame roughly, I suppose, to kind of arrive to a conclusion as opposed to the examinership?
It can be quite short. I think the delay usually isn't trying to prepare the statement of affairs. But the notice of the creditors meeting, I think I just have to check it, Emma, but I think it's 21 days. Okay. So it's quite a short process, and the whole idea is that it works quickly and that it is up to the creditor to press the court button. But the good news is that otherwise court is completely avoided.
So happy, you know, like I said, John, to pass on details if anybody would prefer to speak to John directly. Just one last call for questions. Marguerite, did you want to come in there?
Yeah, I was just wondering, John, very, very comprehensive presentation there, and thanks very much. Just wondering if we can get a copy of the slides. They're good and would be handy to have.
Yes, no problem at all. We'll get that to you.
Yeah, appreciate it.
I get that to Emma.
Send out to Emma, we can get them. Yeah.
Yes, we can circulate then, John.
Certainly, yeah.
That's great. Thanks very much, John.
All right.
Thanks again, John, for certainly a very informative presentation there. And thanks for your time spent on SAME. And like I said, we'll circulate those slides to everybody after today's call. And thanks again for everyone for joining this morning. And like I said, please don't hesitate to reach out to myself or any of the Chamber team on any issues, views or further supports you may need. Thanks again, John.